Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So I can hardly believe that I'm saying this, but for the second time in less than a week, we are talking about yet another victory up at the Ninth Circuit Court of Appeals. This was a unanimous decision by a 3-judge panel, and one of those judges was Judge Van Dyke. This judge, if there's ever a vacancy up at the Supreme Court, this judge needs to be nominated. He understands the Constitution and that it constrains government and not the people. And his opinions and decisions have been absolutely amazing. This time, they ruled in favor of both the First and Second Amendment. So we need to talk about what just happened in the decision that just came out today. Now, real quick before we get started, this channel is proudly sponsored by Attorneys on Retainer. Listen, if you're somebody who carries to defend yourself or your loved ones, or maybe you just keep something in your home for your own defense, having an Attorneys on Retainer membership is like having an attorney in your back pocket that is available 24 hours a day, 7 days a week. It is absolutely priceless because should you find the need to defend yourself, you could still be the one that ends up in trouble. And Attorneys on Retainer will jump in to be there and defend you and take care of you through the entire process. Also, Attorneys on Retainer has an incredible program. They are backed by Attorneys for Freedom, the only law firm in the entire country that does nothing but self-defense cases. They are the self-defense experts. On top of that, they have civil liability coverage, red flag protection, online education and training, and so much more. So if you guys would be interested in having that confidence in your back pocket, check out the link down below. I'll put some savings down there as well. Okay, so let's go ahead and talk about what's going on here. Now, this is kind of an interesting case because this case led to a little bit of California court infighting, I guess is the best way to put it. So this case was already decided by a 3-judge panel back in 2023. That 3-judge panel told the district court to issue a preliminary injunction on behalf of the plaintiffs because the law that was created under California's AB 2571 was unconstitutional, but the district court didn't want to do that. So they only granted the injunction to a portion of that law. And so there had to be more bickering, more battling back and forth to get this back up to the Ninth Circuit so that the Ninth Circuit could clarify that they were talking about the entire law. Now, this is a huge victory. This case is called Junior Sports Magazine's v. Bonta, and it's huge because it's not only just a Second Amendment win, it was also a First Amendment win, and it was backed by some pretty heavy hitters. You had the CRPA, the CRPF, the GOC, and the 2AF all joining forces to get this win. And again, like I said, a major victory dealing with two of our most fundamental constitutional rights. Now, for those of you who don't know what Junior Sports Magazine's v. Bonta is all about, let me tell you, this was one of the creepiest laws that California has ever come up with because it intended to make generational change in California by limiting the amount of information that was available to younger generations. It basically wanted people to grow up not knowing about their Second Amendment rights, and it did that by limiting First Amendment activity that they could then see. Now, I think Chuck Michelle of Michelle & Associates and the president of the CRPA said it best on X today when he wrote, "Today's ruling strongly affirms that the fundamental rights afforded by both the First and Second Amendment are just that, fundamental. AB 2571 was a blatant attempt to destroy gun culture, and it's gratifying to see it roundly rejected by the court today." Now, this is directly from the unanimous opinion from the Ninth Circuit in today's victory, where it says, Junior Sports Mags Inc. v. Bonta, we reversed the district court and clarified that our constitutional analysis applied to the entirety of section 22949.80. Again, giving us a win over that entire section. Now, this is a major First and Second Amendment generational win in the state of California, and that's why this is so big. California will no longer be able to limit the information that the younger generation is allowed to have. Now, there's going to be some people that say, well, isn't this just going to be appealed? And yes, it probably will be appealed. But the first time around, when this was decided by the Ninth Circuit, the state of California asked the Ninth Circuit to rehear this case en banc. Now, in the first time around, they told the district court the same thing. They're just essentially reaffirming that now. But the state of California asked for a rehearing en banc, and that rehearing en banc was actually denied. So the chances of it being heard en banc this time are very, very slim. So more than likely, this is a win that is going to stand in the state of California, and that would be fantastic. Enough going after these generational changes and trying to make people uninformed about what their rights are. This was huge. I'm excited about it. Again, it's the second time in less than a week that we got a win out of the Ninth Circuit on a panel that had Judge Van Dyke on it. Anyway, I wanted to let you know about that. I want to thank you all very much for watching. If you haven't done so already, make sure you hit that thumbs up button. Really helps us out a lot. Subscribing helps us out a ton as well. Helps us share this information with more and more people. And I want to thank you guys, everybody who has subscribed and supports us up until now. So thank you again. Have a good one.